Okay, so thank you all very much for coming out. There's not a ton of new information. I think the only very important thing that was filed was on the 1st of May, last Friday, there was a filing that had two pieces of information that I think were important. The first is the claims resolution procedures, which we call the CRP, and the second are the trust documents. So those were included in the letter that was sent out yesterday. They're also available on the website. So if anyone's interested at all, take a look. There was one portion of the CRP that I was concerned about, and so I mentioned this in the letter, but it does not mention whether or not the individual fire victims are going to be able to recover attorney fees as part of the lawsuit. And as we've talked about many times, that's a critical component. In my view, there is absolutely no way there can be a fair resolution without that. So I've already called the trustee once. I've got a call scheduled with the trustee and the claims administrator tomorrow. And I'm also speaking with all of the other fire attorneys to make sure that we're all on the same page and we have support on this. In my view, this is something that absolutely has to happen. So we are going to keep pushing to make sure that there's an updated statement that includes it. And again, I don't want to create the wrong impression. It's not that they've said it won't be, it's just that they've said they haven't made the decision yet. And so what I want to do is get an updated statement that says that that will be included. And if we don't get anything like that, then I intend to file an objection at the time of plan confirmation, not to the entire plan, but to that one element. And so what we would do as part of that objection, if we do ultimately have to file it, is to ask the judge to make it very clear that anyone who brings a cause of action under the inverse condemnation claim is entitled to recover their attorney fees for that cause of action. I know we've talked about this before, but again, that would be the attorney fees for the economic damages. So that's where we are on that. Most of the questions that we received online related to that. I understand why everyone is concerned. And again, to me, this is critical. It has to be done the right way. So it's something that we're going to keep pushing on. And I'm optimistic we're going to get it done, but it hasn't been done yet. So I know that is a cause for concern. Everyone is right to be concerned about it, and we'll stay on it. That's the biggest thing that's happened. The only other real thing of note is that there was a $1.9 billion fine. I think technically it's 1.9 and 14 million. It's funny when you talk about 14 million, it's not a big number, but yeah, that's what happened. PG&E, and this is part of the negotiations that have been going on for quite some time, that was expected, so it's not going to have any impact on the plan, and this is money that has to be paid by PG&E shareholders. It's not something that there's any argument that victims would have to pay. It's not something that can be passed on. This is punishment for the wrongs that PG&E has done in the past, and frankly, it's well-deserved punishment. What I was pleased about was that it was in an amount that's sufficient to punish PG&E, but it's not so large, you know, 4, 5, 6 billion, where it takes away money that would have to be used to pay the victims. So those are the two, in my view, most important things that have happened since our last call on Thursday. What I wanted to do was just open it up and see what questions people have. We'll start, I know Chewy has a couple of additional questions that were written in. So Chewy, if you want to read those, I'll answer them, and then we'll just open it up.
Sounds good. The first one is, once the disbursement happens, do you know how to handle the payment on that year's taxes?
It's a good question. One thing that I have to really stress is that I am not a tax lawyer, and we do not have expertise in tax law. I can give you the general basic rules, and then beyond that, my advice is always to consult with a CPA, a tax attorney, or other qualified professional who has expertise in this area. If you need a recommendation, we're happy to provide one. There are people who specialize in this. That is, they specialize in the tax consequences of settlements. And so they may be helpful, or you can go to your local CPA. But in a nutshell, here's the rule. When you have a catastrophic event like a fire that destroys real property or personal property, you receive money to compensate you for that, and you use that money to repair or replace your property, then the general rule is that there is no taxable event. So you would not have to pay any taxes because you haven't received any income. The way that our system works is if you, for example, have a home that's burned down, they don't present you with a new home, they give you money to repair your home. So if you were to buy a new home, if you were to repair the one you had, build a new home, anything like that, you're using that money to repair or replace your loss, and therefore there's no taxable event. For recovering something like lost income, that is taxable because the income itself would be taxable. And when you recover non-economic damages, that is also, generally speaking, taxable. There's a certain category that is not, and that's if you suffer a physical injury and you are being compensated for the pain and suffering associated with that physical injury. For example, we have people who, when they were fleeing the fire, suffered, injuries to their legs. We've had people trying to pick things up that have torn rotator cuffs, that kind of thing. If you have a cause of action like that, and let's just use the rotator cuff, you would be able to recover the economic damages for the surgery and the resulting aftercare. You'd be able to recover any lost wages, and then you would get non-economic damages to compensate you for the pain and suffering you've experienced. That would not be taxable. But if you, for example, were not at your home when it was destroyed and you receive money to compensate you for that damage, then that would be taxable. Because of that, we try and skew the losses, and the way that we present our demands, we try to do it in such a way that we, for lack of a better term, we maximize the amount of economic damages. One of the reasons we do that is it minimizes the taxable impact. So that's kind of the general rule. Beyond that, I would really recommend that everyone consult with a tax professional. Finally, I just noticed that this is, you can see this, I'm not in my office today, and my home office was having some work done. So I came into one of my daughter's bedrooms. So this is her bunk bed. That's what I'm sitting underneath. So if it looks silly, that's why, and now you know. All right, Chewy, what is the next question?
The next question is, when will we know the amount that will be demanded for our individual claims?
That'll be when your claim is submitted. Right now, the trustee and claims administrator have said that their goal is to have the system up and running by July 1st, which means that we could start submitting after that. Once we submit that, then you'll know what amount is going to be demanded. And obviously, if you'd like to review it beforehand, just let us know. We're happy to do that. But typically, and thus far, that's been the goal, that it'll be open by July 1st. It may not be July 1st. It may be a couple of weeks after that. But once that process opens up and we can start submitting, then you'll know exactly what your demand is.
Okay, that was a couple of questions that were submitted for this week. I'm going to open up.
Okay.
Anybody who has a question can unmute themselves. I've unlocked that feature, and go ahead and ask.
So this is Naomi Phillips. How are you tonight?
Okay.
Great.
I'm well. How are you?
Good, good. I'm over this pandemic, but that doesn't really matter. It's still here. So yeah.
I think we all are. As I told you, I'm sitting here underneath my daughter's bunk bed here. So yes, I understand.
Yeah. But so you're going to be submitting claims over the process of a few months. Are you ranking cases, or how are you going to figure out who gets submitted first and second and so forth?
That's a good question. There is a priority that we always give in these cases to people who are what are called in the legal system preference cases. And that is the reference, the reason we use the term preference is that it's a legal term of art, and it refers to people who would be entitled to a preference in trial setting because of their age and their health condition. And so what we always do in these cases is the first cases we submit are that few number of cases for people who are elderly and in, unfortunately, poor health, because the concern is you don't want those people to pass away. You want to give them every opportunity to have their case resolved before they pass. So those are the first ones that are submitted. That is always a very small percentage. Usually it's 2 or 3%, sometimes as high as 5%. So it's not going to be a huge number. Once those are in, then it really is, as soon as the case is ready, we submit it. I think the Butte cases, and those are the ones from the Butte, not Butte County, but the Butte fire in 2015, the one that occurred in Calaveras and Amador counties, those will probably be among the first submitted simply because they're all worked up and ready. We had already submitted all of those to PG&E as part of the mediation process, so there really isn't any more work that needs to be done. We could submit those tomorrow, so those will be submitted as soon as it opens up. And then other than that, it's just as soon as the case is ready. That's one of the reasons that we ask everyone to try and get your personal property list done and submitted to us, because that's typically the one thing that we really need from you. My goal is to submit absolutely all of my cases as soon as the trustee opens up the process. Obviously, that's not going to happen, but that's the deadline that I want to give people. I want to encourage people to get it done as soon as possible. And what we find over the years, representing large numbers of people in these cases, is generally there just tends to be a kind of a process. And some people want to do it at the very beginning. Some people tend to take more time. And then some people, for whatever reason, want to be the last ones in line. They feel like they're going to get the most if they go at the end. And so they want to wait. We leave it up to our clients, but my preference is to get these in as quickly as possible so that we can get you paid as quickly as possible.
Thank you.
Anybody else? Feel free. If you're having issues unmuting yourself, please give me a wave here.
I have it.
All right, Jared, doesn't look like anybody else has any questions. I did I think it'd be a good time to, in case somebody else has a question, to remind everybody about. Go ahead.
Hello. Yeah, my name is Ron Irvin. I am in the Butte fire, and my question is, Jerry, you guys you've already done the arbitration with the arborist, the erosion control. Now we've gone on for about 5 years now, and it is no more erosion control. It's about how are we going to handle the erosion that's already been happening for 5 years. Is that how do you handle something like that? I mean, it's going to be twice as much work now. That's my question.
First of all, I have to say, and I think everybody feels this way, it is just so unfortunate what happened to people in the Butte fire, because we were about to settle. The case would have been wrapped up within 3 or 4 months, and then PG&E declares bankruptcy, and so your case is delayed 2 years. And I know that everybody involved, I mean, it's very unfortunate, and our heart goes out to you. In terms of the specific issue that you raised, if you are having problems that are over and above what you were having before, please let us know. And what we'll do is we'll have our hydrologist who prepared the erosion report just do an updated report. And that's not a problem at all. I think probably the easiest thing to do is if you want to just send us an email tomorrow or call the office, we can send you a copy of that report. And if you feel like there have been changes since then, let us know and she can update it.
Okay, thanks, Jerry, I appreciate it.
Does that make sense?
Yeah, I mean, no, yeah, that makes sense. Thank you, I appreciate it. We'll take a look at the report and we'll go from there. Thank you.
Okay, all right, sounds good, no problem at all. Okay, who else has questions?
Jerry, I have one submitted via the chat, and they say, how likely is it that PG&E will be required to cover attorney's fees?
I think it's very likely. I would be very surprised if that doesn't happen. One of the reasons that we chose this particular trustee and claims administrator was because we liked the way that they handled the 2007 fire, and we used it, we call it the Trotter formula, as a blueprint for how we handled Butte and some of the subsequent fires. And a key component of that was that all of the attorney fees on the economic damages were paid. And that way a fire victim receives 100% of their economic losses, and then something over and above that for the non-economic. So they're made whole economically, and then above that, they get something for having gone through it. So I think it's critical. I think it's very likely it'll happen. I think because it's one of those things where there are issues in terms of unrepresented people are saying that's not fair, it's kind of a hot potato, and people tend to put off those type of decisions. My position on that is very simple, though. People who hired attorneys did so with the understanding that they were going to have their economic attorney fees covered. The law is crystal clear. There's no wiggle room. It doesn't say may. It doesn't say could. It says shall. Shall is a legal term of art. It means that there is no discretion not to award it. And so from my perspective, this is something that absolutely has to be done. And as I said, if there is not an agreement at the time of plan confirmation on the 27th, then we're going to file a limited objection to the plan based on this specific issue. And we're certainly going to ask all of the other attorneys for all 70,000 other victims to join in. I think this is a critical issue, and I think it has to get resolved in your favor. All right. Looks like Mr. Barwick. Do we have a question there? Shuey, do we have any more questions?
I have a question, Jerry.
How you doing, John?
Oh, as well as can be expected.
All right. What's your question?
My question is, as you know, a lot of letters get circulated. And one from another attorney expressed a high degree of skepticism with regard to how, you know, whether or not we should be confident about PG&E having the ability to meet the funding for us, as well as their 1054 obligations to exit the insolvency proceedings by the end of August, which, you know, we're taking us into the fire season, which we're already getting warnings about. So my question for you is, what is your response to that? What made really something we
John,
should
I
be worried
lost
about?
you. You said what made, and then you cut out. Go ahead.
Sorry. My question is, what makes you not worried about that? What makes you feel that PG&E will meet their obligations by that August deadline, that they will be able to fund the trust, make the initial payments, as well as their obligations to 1054?
Sure. And I assume that you're talking about the letter from Steve Skikos of Skikos, Crawford, and Skikos?
Affirmative.
Yeah. Okay. Yeah, no, I saw the letter this morning, and I have talked with several other attorneys about it, a couple on the TCC and a couple who are not. One thing that the TCC made crystal clear is that in making this statement, the Skikos firm, and there are actually 3 Skikos brothers, Steve, Greg, and Matt, are speaking for themselves. They're not speaking for the TCC. The TCC emphatically says that they are behind the plan. They are not going to oppose it. So that was issue number one, because one of the Facebook postings that I saw, and this was the only thing that concerned me, was that someone had said, here's a letter from my attorney, the TCC is going to come out against the plan. So at that point, I called the attorneys for the TCC and a couple of the people who represent members of the TCC, and they all assured me that that's not the case. In terms of the motivation of the Skikoses for doing that, it's an interesting question. One thing that, there were 2 things that struck me when I read the letter. First of all, Steve Skikos was one of the people that was in the mediations. There really were only 6 to 8 of us that were in the majority of the mediations, and he was one of them. And the issues that he raises have not changed. There was always a concern about whether or not PG&E could meet this funding. We think they're going to be able to. We think they have the backstop commitments, going to your point, but we're not sure. And there certainly is always a chance that they are not going to be able to do it by August 29th. But if anything, the likelihood of them doing it has gotten substantially stronger since we signed the agreement. It's not like it's gone the other way, where it's less likely. And the reason for that is the backstop commitments that they've obtained. When we signed the restructuring support agreement, the RSA, they did not have anywhere near the amount of backstop commitments they had. This is the $9 billion that they have in backstop commitments, and that's what enables them to make the cash payments that they're going to need to make, not just to fund the settlement trust for the fire victims, but also the AB 1054 money, because they have to put in, I forget off the top of my head exactly how much it is, but it's roughly $6 billion in that area. And it's obviously a big chunk of money. And so that's where that's coming from. They've got $9 billion in backstop commitments that can be used both for that and for the initial trust funding. And that's assuming that they don't raise more money in the initial stock offering. So I was surprised by that. The other thing that really surprised me about it was that a no vote doesn't address any of the concerns that were raised in the letter. All of us, and again, I mean, this is something that we've said from day one, we think PG&E can make these payments, but we certainly don't know for sure. But a no vote doesn't do anything other than not give them the opportunity to. If there is a no vote, then PG&E and the contingency plan kicks in. And a trust, not a trust, it's a, what was it called? It's a restructuring officer, I forget the technical name, but that individual is appointed, there's a committee appointed, and then PG&E's assets are sold off. So I don't know what the purpose of a no vote would be if your concern is that I don't know that PG&E will be able to make the funding on August 29th. If that's your concern, then my advice would be wait until August 29th, see if they do. If they do, great. If they don't, then unless we all decide to give them an extension, the restructuring officer is appointed and they go into a bankruptcy sale. So I just don't understand the logic. In talking with several people, the general consensus seems to be that they are covering their bases. They think that it's very clear that the vote is going to go in favor of the plan. But this way, if the plan is approved and if things don't go well, then none of their clients will be able to say, you gave me the wrong advice. So in essence, it's trying to have your cake and eat it too. You think the plan will go through and you're not doing anything that's going to prevent it. But in the event that there is any kind of a holdup or there is a problem, then you've protected yourself and your clients can't come back after you. I mean, that's there were some choice words that were exchanged when we were talking amongst ourselves about whether or not that was an honorable thing to do. And I mean, everybody has to make up their own mind. It's not the way I practice. I think the plan is the right thing. So I'm telling everyone that. And if it turns out that I'm wrong and it's not the right thing, then that's a consequence that I'll have to live with. But hedging my bets like that is certainly not my style. So to get back to your original question, I don't know what the motivation was. I can speculate. I don't think it's going to make a difference in the plan. I do think PG&E is going to be able to make the payments, but you're right, there's no way we can guarantee it. The one thing I would say, though, is a no vote doesn't in any way increase the probability that PG&E is going to be able to make those payments.
The one concern I had was that it was enumerating issues of which we're aware. It really wasn't offering me an alternative. That said, my follow-ups to that are, when you talk about options, if they don't meet that August 29th deadline, first, is that really something that we would have in terms of an option, in that wouldn't we be almost certain to offer them an extension compared to just say, going back and putting them into bankruptcy? I mean, wouldn't the likelihood be that we would be giving them that would be almost a certainty? And I'm asking that because I wonder how much that can play into how PG&E operates, because we would know that giving them an extension still gives us an opportunity, fire's not standing, versus just saying going into the bankruptcy and settling for what would likely be far less.
Right. Well, and that's a good point. It's funny you mentioned that, because before I got on this call, I had that exact conversation with our bankruptcy counsel, Richard Marshak, who is the one that advises us about this. And his thought on that was, he actually said this. He said, it's going to be fascinating to see what happens on April 30th. Hopefully the plan is funded and we're done and there's no further issues. But he said, if the plan is not funded, and just so you know, if the plan is not funded, then technically what happens is that the RSA is no longer in place and it's withdrawn. However, by a majority vote, those of us who signed the RSA can agree to give PG&E an extension. So the default, if everyone does nothing, is that the deal's over and PG&E falls out. But if we do decide to give them an extension, we could do so. What Richard said, though, and I think there's a lot of truth to this, is that if we don't hit that August 29th, what would probably happen is that, obviously what would definitely happen is there would be an immediate meeting and we would go through and see if we thought PG&E could emerge. But I think the absolute deadline would probably be September 30th, because on September 30th, there are all kinds of penalties that kick in through the CPUC and through the ability of the governor to appoint certain people in executive positions for PG&E. So that would be my guess, is that there would be an immediate meeting and we'd look at it and say, do we want to give them another month? But it's hard to imagine it going much beyond that, simply because if they don't have the funding to do it on August 29th, it's unlikely they're going to somehow acquire that additional funding after they start getting hit with penalties that start at the end of September.
Okay. The only other question I have is purely in the theoreticals. Is there anything that leaves us more vulnerable to being compensated in the event of the settlement is accepted, PG&E does not make payment, and then there is, you know, some catastrophic fire for which they're responsible. Is there anything about that in which we would be more vulnerable in that situation than just flat out declining the settlement now and, you know, following that road?
No, in fact, it's the other way around. In terms of future fire danger, which everyone realizes is a huge issue. I mean, that to me is really, and it's not so much from a fire victim in this case concern. It's just we want there to be safety in the future, and that's one of the reasons that we're doing all this, is that we want PG&E to actually change. But in terms of compensating both future fire victims and making sure that there's sufficient money to pay the current fire victims, there is just one key, and that's whether or not PG&E meets the requirements of AB 1054. If they meet those requirements, then they're golden. They have to pay their insurance, which for this coming year, I believe is $1 billion, and then anything over and above that would be paid out of that $21 billion revolving fund, which, as you pointed out, PG&E has to pay a portion. Again, it's somewhere in the $6 billion range. Edison pays another $4, I think it's $4, it's $4 or $4.5, and then SDG&E pays about $1 billion. The second $10.5 billion is paid by the ratepayers over a period of years. So that's where that money comes from, and that's what will happen. That's what will be used to compensate future fire victims if PG&E meets the requirements of AB 1054. Now, if this plan is voted down and they don't get out of bankruptcy, then obviously that doesn't happen. So in terms of a concern for future fires, if we put aside the obvious concerns about, you know, the life and the property of the residents of Northern California, and we just focus on how it affects the people in this suit, then the most important thing we can do is make sure that they comply with 1054, that they get out of bankruptcy, so that if there is a future fire, it's not going to wipe out all the money that could be used to pay the victims here.
Thank you, Jerry.
Sure.
Hey, Jerry, I do have a question from one of the viewers here. It says, prior to bankruptcy, settlements were subject to a confidentiality agreement, and the settlement amount was not disclosed. Since we are in bankruptcy now, will the settlements be public record?
You know, that's a really interesting question. We, as the attorneys, and certainly we have the support of the trustee and the claims administrator on this, we've asked that all settlements be confidential, simply because, you know, a lot of people are going to be getting a very significant amount of money, and that's private. Nobody else has the right to know that. So that's not something that we believe people should have to share. Now, the problem and the only potential hitch there is that there is a general rule that says bankruptcy proceedings have to be transparent and public. And the idea there was that they didn't want any sweetheart deals where a company goes into bankruptcy and then essentially makes other deals and, you know, is able to use the bankruptcy to make money. In other words, you know, you might sell something for a song to a friend, then they sell it back to you, you get to discharge all your debts, and you still have all of your property. So because of that, they made all bankruptcy proceedings be transparent. What we've argued is that the purpose of that rule is to make sure that everyone knew what all of the creditor classes were getting. So, for example, we know what Subrow's getting. We know what the local public entities are getting. We know that the individual victims are getting $13.5 billion total. And so we're arguing that that number, that disclosure, is sufficient to satisfy the bankruptcy rules. The trustee has agreed with us on that. As far as he is concerned, that the individual settlement should be confidential. So the only hitch will come if someone files an objection to the plan confirmation, and says, we object to this. We think each and every settlement that's paid out to each and every individual should be public. If that happens, then Judge Montale will have to rule on it. We're optimistic that he would see things our way, but I can't guarantee it. So what I can say is kind of a long way of saying we're pretty certain that everything's going to be confidential, that no one will know the amount that you receive, but we can't guarantee it until we see if anybody files an objection.
I don't have any more questions here, Jerry.
All right, folks, does anyone have any questions at all?
Hi, Mr. Singleton. This is
Yes, Jerry.
Linda Oslin.
How are you?
I'm fine. Well, I'm as fine as can be.
All things considered, yes.
All things considered, yes. Thank you. And my husband and I are campfire survivors.
Mhm.
One of my questions is, what if the plan is accepted? I am betting, I am hoping that the plan is accepted. We have done our voting, so that's taken care of. What is the preferred way to submit our personal property list? And what would be an absolute deadline on that for the campfire? Can
Sure,
you give me that?
there's no absolute deadline. It's
Okay.
just like we were saying earlier, we can't submit your entire package until we get that, and I want to get
Right.
everybody submitted as soon as possible. But, really take your time. I mean, particularly
yeah,
the
well.
more recent fires, I know you've been through a lot, so take your time, and whenever you're ready, get it to us. In terms of format, obviously our preferred format would be an Excel spreadsheet. I mean, if we could get that, that'd
Yeah.
be great. But,
Okay.
we'll take it anyway. I mean, you can handwrite it, however you want to do it. We really appreciate you doing that. We know it's a hardship. So whatever works for you, just let us know. If you do want to do it in an Excel or a Word,
Yeah, I can
then
do that.
you can just email it to us, and then
Okay.
we'll finalize it.
Okay, good. Second question, to improve the settlement, prospective settlement, what would be a good way or ways to prove that we were caught in the fire and the escape without cell phone use, or, all the towers had burned, and being caught in the fire for 4 hours? I mean, how do you prove that unless they can download prayers? I don't know how to prove that.
Right. No, I hear you. I don't think we can download prayers, but I think that the first thing that you want to have is a logical explanation as to why you were, and so that the easiest way to do that is just to say, here's where we left from, here's where we went, and we know the number of people that were involved there.
Okay.
It also helps if you have people with you. Obviously,
Well,
if
my
there
dog.
are two of you together. What's that?
My dog.
Your
My
dog.
husband in
Okay,
front of
yeah.
me. Now, my husband in front of me in his vehicle, but we got separated and we didn't see each other until later that afternoon. So.
No, understood. And I don't think that's going to be a huge issue. Obviously, we can look at cell phones and try and track them. As you said, the towers are gone. So it's going to be interesting to see how accurate that is. But, my view is, and obviously we're going to have to wait until we get the final CRP, claims resolution procedures, before we know this. But I think that, again, my opinion, this is not, gospel, but I think this is what's going to happen. I think when we have a situation where you have people who lived in Paradise, who were there at the time, and who have a logical explanation for where they went, why they went that way, and there are two of you, so you can back each other's explanations up. I'd be very surprised if the trustee asked for more. I think where there's going to be issues are when you have people that, and don't get me wrong, there are certainly legitimate situations of people being in unusual places. But when you have somebody who doesn't necessarily live there or who at that time would normally have been at work somewhere else or something like that, that's where you have a situation where you say, okay, this is a little outside the ordinary. We wouldn't expect to see this person in that place at that time, and that's where we're going to need additional proof or explanation.
Okay, thank you. And the other thing is regarding your response to one of the, I think the second to the last caller about PG&E changing. Well, we have relocated to a property in Oroville. We are back in wildfire country. And we work closely with PG&E because now we have our own power pole. And we are doing our own, clearing. We have our 100-foot defensible space because now we have 3.5 acres and we can do that. But we have had experiences with PG&E engineers, people who come up with clipboards and hard hats, and because of the power pole and et cetera. And our experience in the last 18 months with PG&E has been interesting in that what they say they're going to do, they have not done. What they say they want to do, they have not done. And so we are documenting and we're pleasant with them. And in some cases, the PG&E people who come here on the property are survivors, campfire survivors themselves. And
oh, wow.
Yeah, and so they're undergoing, therapy.
Yeah.
But they work for the company that burned them out, so that's got to be tremendously problematic for them. But anyway, I'm documenting because what they say they're going to do is not done. And
that's important. Yeah, you
it's important because we're in wildfire country. We've already had 4 fires in our area in the last 3 days. Not that it was problematic for us, but I'm just saying this is going to be a heavy wildfire season. And
I think you're right. Yeah.
Mm-hmm. So I hope that people understand that documentation is key, because we're going to. I hope we don't go through this again, but I'm not.
No, and you're absolutely right. What I was, and it's important to document on that micro level because that's key. Mm-hmm. What I was referring to though was more of the macro. I mean, in order for PG&E to be safe, it's going to take several years, and they're going to have to make a massive financial commitment. Thus far, they've committed to paying $40 billion over the next 5 years to harden their system. And if they do that, then it is going to be a very safe system, and the likelihood of this happening is going to be dramatically reduced. The issue is, are they going to stick to it? And so while you're absolutely right in terms of your specific area, you want to document everything and do it. But even if they were great on that micro level, what's critical from an overall system perspective is that they spend this money, and on that macro level, they spend those $40 billion over that 5-year period like they've committed to do.
And is there any way for us to, or for me, because I'm on the phone to my representatives for many other reasons, my local representatives, or State Senator Nielsen and LaMalfa and all those people, for other reasons. But is there any way to voice our opinion on this to the PUC, or
Yeah, I mean, there are. I think you can always comment at the PUC. I don't know how effective that is. In my view, the real problem with the PUC, and it's getting better, but when we started doing fire cases, there was, in my view, a very unhealthy, for lack of a better term, revolving door between the PUC and the industry. And so, for example, you had a PUC commissioner who left, waited a year, and then became the president of SDG&E. And so, you know, you have, it's the same problem that we have in Washington with lobbying. It's, you know, we're not saying there's a quid pro quo, but when you're in a regulatory job and you're looking to leave, and then once you pass that prescribed 1 year or 2 year period, get a phenomenally lucrative job at the very company that you're supposed to be regulating, you know, that there's a tension there. And so that has been cured to a certain extent, but from my perspective, we give the PUC all of this authority, but we haven't given it the funds that it needs to really do its job. And so if you are interested in talking with your representatives, what I would say, and what I think the most important thing is, we really need to increase the resources available to the CPUC. If we're going to make them the agency, which we do under 1054, if we're going to make them the agency that's responsible for essentially making sure that all of this equipment is safe, then we really need to increase their resources.
Okay. Well noted. All right. Well, I appreciate this, and
Sure.
I've watched your other town hall meetings online, and so I'm doing this by phone tonight. But thank you so much. I appreciate your answers, and great. Talk to you
My pleasure.
again.
Thank you. Yeah, thank you for calling. All right, Chewy, who do we have next?
I have a question here. It says, can you explain the interest portion, how the interest portion will work, and will we receive the interest payment or award directly, and what attorney's fees will be due from that?
Sure. You know, that's an interesting question. That's the other thing that's up in the air. Under inverse condemnation, you are entitled to get interest on any economic damages that you suffer. The problem is the way they've interpreted that is it is a phenomenally low interest rate. It's substantially less than 1%. So it doesn't really move the needle that much. I mean, obviously we want to get you everything we can, but right now the two issues that have not yet been decided, or two of the main issues by the trustee, is whether or not they're going to award attorney fees and whether or not they're going to award interest. My perspective is going to be that we need to fight for the attorney fees. I think, to me, that really is a sine qua non. That has to happen. With the interest, I would like to see it happen. I think people are entitled to it, but it is not going to make a significant difference in anyone's award, simply because the way that it's calculated, and there's a complex formula, it has to do with the surplus rate, and given how low interest rates are right now, I mean, it is substantially less than 1%. So if it happens, it'll just be added on to the economic damages, and it'll be part of the total award. My guess is they probably won't do it, but we'll have to wait and see what they finally decide.
Thanks, Jerry. And I have another question submitted here. It says, how will the costs be handled? Is it a certain percentage for everyone, or how do those costs get divided?
Sure. It's there are two types of costs. There are the individual costs that vary from case to case. If, for example, you were a renter, then you're not going to have, in all likelihood, any individual costs, because the only damages you had that are economic are going to be alternate living expenses, the personal property loss, and then perhaps lost wages or something like that. That's the kind of the standard renter case. On the other hand, the standard homeowner case is going to have a couple of different experts. One is going to be a rebuild expert, a construction expert, and then in addition to that, you'll probably have a landscape arborist, something like that, who's going to tell us how much it's going to cost to put that aspect back together. And then in some cases, usually about a third or so, there'll be an erosion expert as well. Each of those is going to be separate, and those costs are individual. So each individual pays whatever their costs are. In addition to that, there are joint costs, and those are the liability costs that are necessary to prove up the case. So we're talking about in a case like Tubbs, for example, where we had to do a lot to prove it up, then those are going to be assessed for those plaintiffs. And obviously we have a large number of Tubbs plaintiffs, so it'll be assessed amongst all of them. I think we have 1,000 Tubbs plaintiffs. So let's say that the costs were $100,000. It's done on a pro rata basis. So if you received 5% of the total amount of money that was awarded to the Tubbs plaintiffs, then you would pay 5% of the joint costs. So it ends up being a very small amount of everybody's settlement. Typically, it's substantially less than 1%. We usually put in 2 as kind of a metric because we don't really know what it's going to be. But again, usually it's less than 1%, and it just varies case to case. In a case like Camp, where there really was no liability workup, I mean, there was a little bit at the beginning, but bankruptcy happened so quickly and PG&E acknowledged it so quickly that, I mean, we had a couple of experts out there, but it's not much. So that's going to be just infinitesimal. The one that we did the most work on was Tubbs. There was also a significant amount of work in Redwood and some of the other ones. But, that again, it's case by case. It's typically less than 1%. The most it'll ever be is 2%.
Thanks. I have a follow-up on the question about interest. How does that apply to the Butte fire victims since it's been, 5 years?
Right. Well, the way that it works is that everyone in a specific class, so if you're an individual fire victim, everyone in that class must be treated equally. So initially, the trustee was toying about giving interest to Butte fire plaintiffs because they'd had to wait for so long. But then he realized that legally that would not be possible. So, there's always a chance that they will give interest. If they do, then obviously the Butte fire plaintiffs will receive more because they've been waiting longer. Again, my guess, though, is that they're probably not going to do it. You will just have to wait and see. All right, Jerry, what's next?
I don't have any more submissions here on the chat.
All right. Do we have any more questions on the board?
We do have just a poll that launched just to see how many of the people on here tonight have voted so far.
Okay. Again, on voting, you should not be receiving any more texts and calls. We got at least one to everybody, we believe. And again, I want to apologize for that. There was the issue with the smartphones, so we wanted to give everybody the chance to vote. But you still have 8 days to vote. So anybody who wants to, if you're having any kind of trouble, call us up, whether it's yes, no, we'll vote however you want, but we want to make sure that gets done. So please call us if you need any help.
I do have,
does anyone? Go ahead.
There's one more question here that was submitted about,
Sure.
Do we have the status of how the vote's going?
Yeah, the vote is overwhelmingly in favor. It looks like right now there are about 95% of people who have voted. There's about 25,000 votes, and it's about 95% in favor. We're not going to know for sure until next week. They're going to give a preliminary estimate at the hearing on Wednesday, but it will take another probably 10 days or so for Prime Clerk, which is the vendor, to tally all the votes. I don't, realistically, I don't see any chance of the plan not passing. There's always a chance that we could get a stampede of no votes, but, thus far, with 95% in favor and about about 40% of people voting, it doesn't look like, there's really much doubt.
Okay. Yeah, no more submissions here, Jerry.
Right. Okay. One last before we get off. Remember, if you want to join the Saturday town hall, it's probably not going to be much different, but there will be several attorneys, so you may hear different perspectives. By all means, please feel free. And again, any questions or if you want us to help you vote, please let us know, and we're happy to do so. All right, everybody, take care. See you soon.